All right, guys, well, here we go. Let's do the very last lecture of the semester, not just wrapping up our unit on civil rights and the 14th Amendment, but really, this is it. This is our last lecture of the semester. Shouldn't be too long. We'll come back together after you watch this lecture in class and discuss whatever you want to discuss, and then wrap up our course. But here we go. Remember what I've said, from the beginning of this lecture series last week, that the 14th Amendment doesn't command us to treat everybody equally in all instances. That's not the command of the 14th Amendment's Equal Protection Clause. Its command is that we treat people equally in reasonable ways, right? It's that essentially there can be some distinctions made between people. It's simply that they can't be unreasonable. So, kind of the sequencing of this unit. We discriminate on the basis of age, right? Frequently, we discriminate on the basis of age in our laws, right? We discriminate on the basis of gender sometimes, right? We have, for example, women are not subject to the draft, and yet men are. All of those are considered to be reasonable discriminations. It's perfectly reasonable and not violative of the 14th Amendment to say, well, you're 10 and thus you can't have a driver's license, or you're a woman and thus you're excluded from the draft, right? Or you are rich and therefore your income tax bracket is 30%, but you are middle class and it's 15%. These are all sort of reasonable discriminations, right? The command of the 14th Amendment is essentially that people be treated reasonably equally in the eyes of law, recognizing that there are plenty of legitimate times when government essentially may discriminate. What I want to close out this unit on is by looking at essentially, really the last civil rights movement to sort of crop up, grabbing onto the language of the 14th Amendment. And by the way, it's really blacks that get the ball rolling here in the 1950s and 1960s with the civil rights movement. And what will happen over the next really 50 years from the Martin Luther King, Malcolm X inspired civil rights movement is other marginalized groups will sort of climb on the backs of the black community and the successes and victories they won in the civil rights and say, and us too, right? This is why, for example, it's not really until well into a black civil rights movement that you get a women's rights movement. And it's into the 70s where you see a Hispanics rights movement, right? And so here we are. We're going to finish our unit by looking at what I think is the most recent civil rights movement. You've been watching it unfold, and that's the gay rights movement. This question of, can governments, state, local, federal, can businesses discriminate on the basis of sexual orientation? Now, I've got a lot of text up here, and we're going to get down to the one that's in your lifetime, Obergefell versus Hodges, right? This is what I keep referring to as the love wins ruling, right? Where the Supreme Court essentially says states may not deny access to marriage on the basis of sexual orientation. We'll get there in a few minutes because that ruling is not just out of the blue. Like Roe versus Wade, built on other previous rulings regarding sexual privacy. Remember, think back to our last unit, right? You don't get to Roe versus Wade, the Supreme Court saying abortion's in the Constitution, you just can't see it, without going through a series of cases kind of tearing up to that landmark ruling in Roe. You get, for example, Griswold versus Connecticut in 1965, 8 years before the Supreme Court says abortion's in the Constitution. They articulate that so is a right to privacy, and therefore abortion is a fundamental exercise of a right to privacy. In other words, you don't just get to Roe. The Supreme Court doesn't just roll over one day and say, well, abortion's in the Constitution. Well, likewise, in 2015, the Supreme Court just does not declare that gays have a right to marry in the Constitution. You just can't see it. It requires a stair-stepping of some cases. Now, this is going to get weird. This is going to get awkward. Every year when I teach this in class, like in an in-person setting with people in the room, there's some fidgeting in the chairs. Okay, so let me kind of work my way through this. And again, this is your content warning. If you have younger siblings in the room, get rid of them because this is about to get inappropriate for immature ears. Okay, the first real Supreme Court case to come down as to this question: can a government, state, local, federal, essentially treat people of non-traditional sexual orientation, we'll call that, we'll just go with gay, right? Can a government, state, local, or federal, essentially treat gay people differently than non-gay or traditionally straight people? And the first question that the Supreme Court tackles in this is a case called Bowers versus Hardwick. So I'm going to kind of give you the details of this. And again, this is where it's going to get awkward and weird and uncomfortable. So any young ones, this is your warning. Here we go. Bowers versus Hardwick came out of Georgia. Okay. Hardwick was a gay man whose roommate, not him, but his roommate, he lives in an apartment or a house of some, I think he lives in a house. This is just outside of Atlanta. And Hardwick's roommate is under investigation for something. I don't remember exactly what, drugs perhaps, or something along those lines. The police show up to Hardwick's house to serve this warrant a judge has issued to go search for evidence. Again, they're not serving it on Hardwick. They're serving it on his roommate. But as the cops are executing the search warrant, they go upstairs to the sort of bedroom portion of the house where Hardwick is engaging in sex with his boyfriend. Okay. Sodomy, right? Anal sex with his boyfriend. Okay. Sodomy for our purposes is any same-sex sexual conduct, right? And so there is Hardwick. Now, again, the cops are there serving a search warrant, totally unrelated to this. It's not like the cops went, you're a gay man, let's stop by and see if you're having, anal sex with your boyfriend. That's not what's happening here. The cops are here to serve a search warrant. And in the process of serving the search warrant, they go up to the upstairs of the room and Hardwick is having sex with his boyfriend and the door's open and the cops see it. And as they are executing the warrant, they also arrest Hardwick in violation of Georgia's criminal sodomy statute. Now, every year when I teach this, somebody will ask the question, well, why would a state ban this sort of behavior? Listen, governments throughout all of human history, it does not matter what society you are looking at, have morals-based laws regarding sex. You might not think it's fair, but let's be honest about this, that essentially there are plenty of sexual behaviors that society can, through its laws, criminalize disfavor, right? Traditionally, we disfavor and criminalize incest. We disfavor and criminalize bestiality, right? Sex between man and animal, right? Most human history, these sorts of laws, whether you find them proper for government to pass or society to pass, generally speaking, we all have these. And by the time we get to the 1980s, every state in the union, including our own, has a law criminalizing sodomy or same-sex behavior. Now, really, actually, for our purposes, we want to talk about anal sex here. Okay, there was a statute, a law on the books in Georgia that criminalized this particular behavior of anal sex, right? And so let's go back to the case. Hardwick is arrested and charged. And now it's a minor fine. I think it was like $100 fine or something along those lines. And he pays the fine, but he decides to challenge the law. And he says, listen, it is unconstitutional for this state to have this law because you are targeting me with the application of this law. In other words, had you stumbled upon a husband and a wife, a heterosexual couple, engaging in this behavior, you, dear police, would have never issued this ticket. You would have never enforced this law. But because I'm gay, you saw me engaging in a behavior and you decided to take it. In other words, you enforced this law on me because I am gay. And Hardwick says, I believe that violates the Equal Protection Clause of the 14th Amendment. In other words, Georgia, you would never apply this to a straight couple. You're only applying this and enforcing this to me, a gay man. It goes all the way up to the Supreme Court. And the Supreme Court actually upheld Georgia's law criminalizing sodomy because the way the law was written, the court said it applies to the act. In other words, the law was not particular to same-sex anal sex. It was anal sex as an activity, right? And so I told you this was going to get weird. Georgia's law pertained to the actual behavior, not who was engaging in it. And so what the Supreme Court said is there's no violation of equal protection in this case because, well, the law, the way it's worded, could apply to heterosexual sex, anal sex between a man and a woman, a husband and a wife, a boyfriend or a girlfriend. In other words, what the Supreme Court ruled is, sorry, Mr. Hardwick, the 14th Amendment's Equal Protection Clause doesn't apply to you. Georgia is not targeting you because you are gay. They are targeting a particular behavior that most every state in the union or every state in the union and most societies disfavor with their law. And too bad, so sad, Mr. Hardwick, the Equal Protection Clause does not apply. Okay, so now jump forward 17 years to Lawrence versus Texas, okay? And so I don't remember the exact details in Lawrence v. Texas. I never remember the actual details of this, but here's what's interesting because, so we have our first step, right? Where the Supreme Court says, sorry, equal protection does not apply on the basis of sexual orientation, right? Okay, now we get forward 17 years. And essentially in Lawrence versus Texas, the Supreme Court overturned its ruling in Bowers, but here's the catch. Here's the catch to it, okay? Texas's statute also criminalized the act, but Texas's law was specific to whom? To the participants. In other words, Texas's law was written in such a way that heterosexual anal sex between man and wife, man and woman, was perfectly fine and not illegal in the state of Texas in 2003. But male anal sex, or in some manner, I don't know, female anal sex was criminalized. So Texas's law actually specifically targeted same-sex sexual behavior. And that law, Texas's law, was declared unconstitutional. But here's the real rub. Here's the catch here. The Supreme Court did not rule it unconstitutional on the basis of equal protection. They did not say the 14th Amendment prevents you, state of Texas, from treating gays differently in your law than heterosexuals. Okay, they sort of dodged the equal protection issue because of the kettle of worms it might open. The Supreme Court, by the way, likes to do that. If they don't have to rule on something, they don't. And so here's how the Supreme Court essentially invalidated Texas's same-sex statute. They said, listen, Lawrence and his boyfriend, again, I don't know the details. I don't remember the details of Lawrence. But listen, Mr. Lawrence, you were engaging in private consensual sex with another adult in the privacy of your own home. In other words, this is not an equal protection thing, Mr. Lawrence. We're declaring that law. We believe you're right, Mr. Lawrence. That law is unconstitutional, but not because the 14th Amendment says so, but rather, listen, the sexual behavior of private consenting adults in the privacy of their own home, well, should not be regulated by government, right? And so, Mr. Lawrence, you're right. That law is unconstitutional, but not for the same reason you think. See, Lawrence was arguing essentially the law itself, it violated the 14th Amendment. And the Supreme Court said, yeah, not so much. It doesn't. They ruled it on privacy grounds. You're right. That law is unconstitutional, but simply for reasons of privacy, right? Which, by the way, Justice Scalia, who died a few years ago, wrote a dissent, just like a blistering dissent in this case, actually making fun of the court, not really making fun of the court, actually chastising the court for ruling it on privacy grounds. Because I remember at the time, Scalia said something like, well, that's insane. There are plenty of reasons society might care what goes on in the privacy of somebody's bedroom. Crimes can be committed in private, right? Rape can be committed in private. Child incest can be committed in private, right? And so Scalia said, this is crap. Ruling it on privacy is utterly stupid. But nonetheless, by the early 2000s, it was not considered a violation of the Equal Protection Clause to discriminate on the basis of sexual orientation, right? Now, there's a tiering here. That issue was brought up in Lawrence, but the Supreme Court essentially gave it a nod and set it aside and ruled Lawrence on privacy grounds. Now we jump forward about 10, 12 years here, okay? And this gets us to Love Wins. As recently as 2009, 33 of the states, including our own, had amended the state level constitutions to prohibit gay marriage. Okay, to prohibit gay marriage. And there's a reason. Actually, let me step back for a second before I get to Obergefell, because I need to give that a little context too. Same-sex marriage didn't just come up after Lawrence. In the early 1990s, Hawaii, believe it or not, became the first state in the union to legalize gay marriage. We'll go all the way back to the beginning of our course when we were talking about federalism. Article 4 of the Constitution has that full faith and credit clause. And it says, generally speaking, so every state in the union must honor and abide by and give weight to the laws of the other states. I think in class back in September, I probably taught this is why you can drive in, Wyoming with your Colorado driver's license. You got a driver's license through a legitimate process in a neighboring state. Ergo, Wyoming says, well, you may drive here and not have to get stopped at the border and get one of our licenses or go through that process. That's the full faith and credit clause of the Constitution. Well, Article 4 also, if you remember correctly, allows an out to be carved out by Congress. So if some state passes an outlier law, okay, the other 49 states can turn to Congress and go, we want an exception carved out of full faith and credit. So we don't have to, sort of honor or follow this particular law. Well, now let's go back to the gay marriage thing. In the 1990s, I don't remember exactly what year, 93, 94, 95, somewhere in there, Hawaii became the first state to legalize gay marriage. The other 49 states turned to Congress and went, well, that's nice for them. We shouldn't have to enforce it, honor it. In other words, if a gay couple gets married in Hawaii and gets on a plane and comes to Colorado, we want an out. Colorado should not have to recognize that marriage as legal. We want an out from full faith and credit. And Congress passed a law. Here, Congress in the late 1990s passed a law that just gets colloquially known as DOMA. It stands for the Defense of Marriage Act. And essentially what Congress did was they granted that carve out. They essentially said, and remember, this is all Article 4, Congress can carve out exceptions to full faith and credit, right? And it did. And it basically said to the states, you are free to not grant full faith and credit to gay marriages performed in another state. Okay. That's perfectly constitutional. You don't have to agree with it, but that's what Congress did. And Article 4 allows them to do that. And over the next 10 to 15 years, 33 states went ahead and took advantage of that carve out and amended their state constitutions. Colorado was one. And Colorado said, listen, we accept marriages done in the other states, except for same-sex marriages. We do not recognize them as legal. Okay. And so we get to 2009, and roughly 2/3 of our states have taken Congress up on that out. Okay. Well, one by one, those carve-outs had begun getting struck down by state and federal courts. Ours was struck down. I don't know how old you would have been. 6, 7 years ago, you'd have been about 11 or so. When you were 11 or 12, the Colorado Supreme Court struck down as unconstitutional Colorado's state level amendment banning gay marriage, or at least not recognizing it. Okay. And said, so in other words, by the early 2009, 2010, 2011, we started to see a series of federal and state level courts saying, dear Colorado, your state constitutional amendment banning gay marriage violates the Equal Protection Clause of the 14th Amendment. Now you are specifically and intentionally discriminating in the institution of marriage, the legal recognition of marriage, on the basis of sexual orientation. Colorado's got struck down as violating the Equal Protection Clause, okay, in 2009. So now we have a situation where in a handful of states in the union, gay marriage bans have been declared a violation of the United States Constitution, 14th Amendment Equal Protection Clause. But in some other states, it was perfectly fine. In other words, federal courts, and say, I'm making this up, Georgia nobody had declared Georgia's ban on same-sex marriage unconstitutional, but Colorado's had been. And so we had this patchwork where gay marriage was a constitutionally protected right in some states in the union, but unconstitutional or not legal in other states of the union. That, by the way, is one of the times the Supreme Court will almost always take up a case. When you have got some federal courts in this region of the country, let's say the 12th Circuit has declared gay marriage bans unconstitutional, but over here in the 9th Circuit, the federal appeals court has said, now they're perfectly fine. Now we have a conflict. We literally have, well, okay, so over here, it's a fundamental constitutional right, but if you travel 500 miles east, it's not. That's not going to work, right? That the Constitution cannot mean one thing in one region of the country and a different thing in another region of the country. So this set up this sort of perfect storm where this question of, can states ban gay marriages, or is that a violation of the 14th Amendment Equal Protection Clause? Now, remember, in these previous two weird cases that I brought up, the Supreme Court specifically said the Equal Protection Clause does not apply to discrimination on the basis of sexual orientation. Here and here. Now we have a question. Can states essentially ban the access to the institution of marriage specifically and intentionally on the basis of sexual orientation? And now we get to the Obergefell ruling, or essentially what I've been referring to as love wins. And it held that the 14th Amendment's Equal Protection Clause does apply to discrimination on the basis of sexual orientation. It was about the institution of marriage, but it was a groundbreaking decision, and it had not a damn thing to do with love winning. That was a nice, cute little moniker. And you saw gay couples proudly going within a week of this to their, state courthouses or Taj Mahal and getting marriage licenses. And while that was all nice and, fuzzy and heartwarming, it didn't have a damn thing to do with the Obergefell, right? And by the way, I can't remember the exact name or the exact situation here, but Obergefell came out of Ohio. And if I remember correctly, Obergefell was a gay man who had been with his partner for, like 3 decades, like 30 years. It was a really, it was a real Brown versus Board of Education kind of moment because it tugged at the heartstrings, right? Obergefell was a gay man who had been with his partner for like 2 decades, 3 decades, something along those lines. Okay. And his partner had fallen ill, cancer or something along those lines. But Obergefell was not able to go visit his partner because he was not married to him. And the hospital policy limited people in, I think, the ICU to immediate family, spouses, children, etc. Well, he was not a spouse nor a child, and thus he did not apply, right? And so Obergefell filed a lawsuit and said, my partner of 30 years, I cannot go see, and that's a discrimination on the basis of my sexual orientation, because if I were allowed to be married, the 14th Amendment would essentially let me into that hotel room. And so we have an Equal Protection Clause question here. This goes all the way up to the Supreme Court, and the Supreme Court, for the first time in the history of the 14th Amendment, said it is unconstitutional, it is violative of the 14th Amendment's Equal Protection Clause for a state to discriminate solely and specifically on the basis of sexual orientation. And here we are. The 14th Amendment has been slowly applied first to blacks in the civil rights movement, then to women. So it's a discrimination to violate on the basis of gender or sex, right? It is a violation of the Equal Protection Clause to unreasonably discriminate on the basis of age. And now, in the last 5 years, the 14th Amendment now has been applied to this new group of folks, the gay rights movement, right? It was about marriage, but the reason it was an earth-shattering, listen, this is the Brown versus Board of Education for the gay rights movement. Okay, that's really what this is. This is the Brown versus Board of Education ruling for the for the gay rights population of the United States. And it essentially says the Constitution prohibits disparate treatment against you on the basis of your sexual orientation. It can't be done. Okay, now I anticipate when we get together for conversation in a little while that somebody's probably going to bring up the Lakewood Baker case from a couple of years ago, right? Where this is what always comes up in the last couple of years here in our community. There was a baker in Lakewood who makes specialty cakes for birthdays and weddings, and he refused to make a cake for a gay couple here in our community. This is at Lakewood, Dennett Lake. oh, I don't know. It's like South Wadsworth, down by like Wads and Bowles kind of area, right? And his case went all the way up to the Supreme Court. And the question was, did he discriminate on the basis of sexual orientation? In other words, was he unequally treating people on the basis of their sexual orientation? And that case was really, really interesting. And the Supreme Court ruled that the baker was fine because he didn't deny access. He just refused to go beyond that to create a customized special cake that violated his rights of religion in the First Amendment. So if somebody remembers during the discussion portion to bring this up, if that's something that you'd like to talk about, I will happily explain that case because it's really interesting and very nuanced, right? That case called Masterpiece Cake Shop versus Colorado Department of Civil Rights is actually the name of that case or something along those lines. But I'll happily talk through that case in the discussion session of this class period. So let's wrap this up. And I'm going to burn through this. And again, we can leave this for discussion as well. We wrap up our look at the civil rights unit by talking about this notion of affirmative action, right? Remember how I started this unit. Civil liberties are things government can't do to you. Civil rights are things government can do on your behalf to help you realize the liberty and live freely and to pursue your happiness. And so in the last 20 to 30 years, a lot of states and the federal government have essentially given, well, some sort of compensatory treatment to people who have historically been disadvantaged, treated unequally because of some attribute, their race, their gender, their sexual orientation, something along those lines. And this is what we call affirmative action. Affirmative meaning positive, right? To affirm means to give a thumbs up or a yes. Affirmative action is this policy of giving special attention to groups and maybe even a leg up to groups that have historically been barred from certain aspects of American life. And this question of, is affirmative action itself a violation of the 14th Amendment's Equal Protection Clause? So let me give you an example here before we hit these two cases and we start to wrap all this up. And again, I'm just going to quickly lay this out, and then we will, I'll leave some time in the discussion portion to flesh this out if anyone wants to talk about it. But you all know that if you are an ethnic minority, okay, you are Black, you are Hispanic, you are Asian, there are scholarships specifically set aside for you on the basis of your ethnic identity or race, right? There are some scholarships that are open only to girls and not to boys. The question is that okay? Is that okay to say, you're Black, this scholarship is available to you, but you're white, you're not? Now remember where we started this. Is that a discrimination on the basis of race? Abso-freaking-lutely it is. Now the question is, but is it a reasonable one? Okay. And the Supreme Court essentially said somewhat yes to affirmative action programs. And by the way, you all know, like, for example, I mean, if you are Black, you may actually have a higher, you may actually get almost awarded for being Black. Or Hispanic or whatever in the college admissions process. I don't think I'm telling you anything you don't know, but let's kind of work our way through this a little bit, and I'll close it out and we'll leave it open for some conversation. This first came up in California in 1978 in a case called Regents v. Bakke. Okay, California had a policy of affirmative action. If you are Black and you apply to any of the UC schools, Berkeley, Davis, Irvine, whatever, if you are Black, you essentially, we're going to set aside a certain number of seats. I'm going to make up a number here. Let's just say at UC Irvine, there are 1,000 admits. There's going to be 1,000 students coming into the freshman class next year at UC Irvine. Of that 1,000, we're setting aside, University of California is setting aside 200 of those 1,000 admissions for minority groups, for Blacks. So in other words, if you are Black, you can compete for either these 200 or any of the other 800. But if you're white, you're only competing for one of 800 seats. And so Bakke was a white student. And he said, well, wait a minute, this is unconstitutional. You are actually discriminating against me on the basis of race. In other words, if I'm black, I can take any one of these 1,000 seats. But if I'm white, I can only compete and take one of these 800 left over because I'm not black. So I can't compete for these 200. I'm just stuck competing for these 800. And Bakke said, that's a violation of the Equal Protection Clause. You are now essentially discriminating against me because I'm a member of a majority group and not a minority group, right? And what the Supreme Court ruled in Bakke is this: quotas are not okay. That violates the 14th Amendment Equal Protection Clause, but race can be considered in admissions. In other words, you can give a leg up to black applicants because they have traditionally and historically been barred from access to higher education. Remember, it takes Eisenhower sending 10,000 federal troops to get 9 black students into Little Rock Central High School, or more to the point with the university setting. It takes the same level of federal troop commitment by John F. Kennedy to get James Meredith, the only black student, integrated in Ole Miss in 1961. And so what the Supreme Court ruled is, listen, man, blacks have been, minority groups have been historically barred from access to this institution. So states, you are free to consider race in the admissions process to sort of make up for the fact that you have discriminated against them historically, but you just can't do it in this way. So it is not constitutional. It is considered a violation of the Equal Protection Clause for a university to go, we're setting aside 20% of our admissions this year for ethnic minorities. That's not constitutional, but it is okay for you to say, well, but we're going to somehow grant a little extra credit for minority groups in the selection process. And that brings us to Grutter v. Bollinger. Race can be considered a plus factor, but it cannot be a deciding factor. So if I remember correctly, I think this was out of the University of Michigan. And the University of Michigan had and I'm going to make up the numbers, but I'm not too far off, that in order to be admitted to Michigan State University, you had to score, let's say there was a 100-point scale. And so many different things got you points on the way to this scale. And when you hit a certain threshold, you were admitted. So for example, a perfect SAT score was like 25 points, right? A grade point average of 4.0 was worth 15 points, et cetera, right? So I just want you to imagine that there's this scale, and once you hit 100 points, you are admitted and a conversation. Well, Michigan said, well, we're awarding 20 points on the basis of race. So if you are black, you get 20 points that if you are white, you don't, right? Remember, a perfect SAT score gets you 20 or 25 points. And so now we have these two equally qualified applicants, right? White and black. And when we add up all these other points, the black guy's got 90 points, the white guy's got 80. Because the black guy is black, he gets this 20 points that the white student doesn't have access to. Black student is admitted, white student is not. Black student got pushed over that line, that admissions line, because of his race. And the Supreme Court said, well, wait a minute, that's not okay. Race can be considered a plus factor. In other words, Michigan, you are free to give a little extra credit to the black students because they've been historically barred from access to this, but that extra credit can't be the deciding factor. And so we're in this weird sort of situation where the Supreme Court has said affirmative action itself doesn't violate the Equal Protection Clause, but quotas or making race the deciding factor, well, that may be a violation of the Equal Protection Clause, right? And we can talk about this because there is other, and I'm going to leave you with this right here, because this is where I'll end it and we'll come together in conversation. Let me give you other examples. This can be in employment, right? If you are black and applying for a job, well, your race can be considered in the hiring process. Okay, I'll go to one that actually involves us. That's Pena, Federico Pena, the namesake of Pena Boulevard. Okay, and this came out of Denver. Adirond, Colorado had a law, or I think it might have been Denver. The city of Denver had a law in the early 90s that said in the awarding of city construction contracts, preference will be given to minority-owned construction firms. So in other words, if the city's got a construction project, let's say a roads project, and I own a construction firm as a Whitey McWhite over here, and I go and I bid this job that the city's got, and you are a Black-owned construction company, and you go bid this job, that the city can actually take into consideration that you're a minority-owned business in the awarding of this contract, right? Because historically minority-owned businesses have maybe been barred from sort of lucrative city government contracts, right? And the Supreme Court said, well, that's fine as long as it's narrowly tailored. In other words, if you are specifically disfavoring whites-only construction firms, that's a problem. But if you're giving a little extra credit in some sort of narrowly tailored manner, well, then there's no 14th Amendment equal protection problem. And I want to leave us right here. This is where we'll end it right now, and we'll come back together and we can talk about this, because essentially, let me jump right here, because this is actually where we ended. Is affirmative action essentially reverse discrimination? Remember that the 14th Amendment says that people must be treated equally under the law, cannot be discriminated on the basis of race. Well, this poses an interesting challenge to us. We can both simultaneously recognize that Blacks and other minority groups have been barred from institutions in American life and society because of their race as a minority group member. But does affirmative action essentially essentially discriminate against the majority group in the name of righting past wrongs for minority groups, or sort of lifting up those who have been historically barred, right? Does the 14th Amendment essentially allow for the unequal treatment of the majority in the name of righting past wrongs done to the minority? This is an interesting question. How does a society right past injustices while preserving the Equal Protection Clause and the commands of the Equal Protection Clause? And let me just show you, this isn't some sort of philosophical question. I'll end it right here by actually going out to the Google machine. And let me project this here. If I just type in affirmative action and I go to, now let me come back out here. If I go out to the Google machine and I type in affirmative action and I click on news, here you are. 1 month ago, California rejected racial preferences again. A majority voted against repealing the state's ban on affirmative action. 70% of Asian Americans support affirmative action. Lawsuit challenges UNC, University of North Carolina's affirmative action policies. It's a really controversial question. Remember, and this is where we end it, the 14th Amendment says people must be treated equally in the eyes of the law, cannot be discriminated on the basis of some attribute of them, their race, their gender, etc. But affirmative action poses an interesting question. Can the majority essentially be unequally treated by government in the name of uplifting a historically oppressed minority group? It's an interesting question. And my friends, that is where I will end it. We'll come together, take a little break for yourself, come together in a few minutes, and we'll have a discussion and we'll wrap up our semester. But congratulations, you have made it through the very last formal lecture of this semester. Just some quick closing comments. I hope that you have learned this semester. I hope that these lectures have been good. I hope that they've been informative. I hope that you've taken them seriously and that my time hasn't totally been wasted in this environment. And I appreciate you playing ball with this otherwise weird semester, right? This is not my vision of good teaching. I don't imagine it's your vision of good learning, but here we are. And I really appreciate that you've played ball with me this semester. So I'll see you in a couple of